Welcome, members, to the 5th series of Know Your Tribunal. As per our advert today, we are going to have two esteemed panelists being led by our good Professor Gidu Muigai, CS, chairperson of the Public-Private Partnership Petition Committee, and Liz Lenjo, the chair of the Copyright Tribunal. With no further ado, we'll have to start the session. And we want first to have the panelists introduce themselves in their own words. Let's kick off. Please, we'll start with you.
We'd have started with senior counsel.
He has a lot to tell us.
All right, so good afternoon, everyone. Thank you to LSK Nairobi for the invitation. My name is Liz Lenjo, of course, a fellow advocate like those of us present. I specialize in intellectual property, entertainment, media, technology, and fashion law. And I run a legal consultancy firm by the name IIP Legal Studio. As informed, I'm the chair of the Copyright Tribunal, recently appointed. Previously, I served as a member of the Copyright Tribunal, where I was appointed by Honorable Professor Senior Counsel, Professor Gidu Muigai. On the side, I also teach Copyright X by Harvard X, the Kenya chapter. So I'd be inviting lawyers who are interested in that course to apply next year. It's usually, applications usually in January, February, thereabouts. It's a free course. However, in the event that you miss the minimum classes, then there's a fine that you pay. So keep an eye out for those applications. I also am a part-time lecturer at the Strathmore Law School, where I teach media and entertainment law. And I also sit as a volunteer head of legal at the Kenya Fashion Council, head of intellectual property and policy. Thank you.
Wow, thank you very much for that. Prof, the floor is yours.
I just want to make sure I'm sitting properly. Not in my office. My name is Gidu Muigai. I have been an advocate of the High Court of Kenya since 1985. I am professor of public law at the University of Nairobi, and I have been a partner at Mohammed Muigai LLP since 1988. And I'm a very proud member of the Law Society, and I was privileged to be asked to come and say something about what my tribunal does. And I look forward to a good hour of discussions around that. Thank you very much.
Thank you very much to both Professor Gidu Muigai, CS, and Liz Lenjo for that introduction. Members, as you're going to kick off the session, if you have any question, any comment, please remember to share them or any concern at the chat section so that you can address them to the panelists through the branch. The next, thank you for the introduction. Starting with Prof, we want to know from you about the history of the Public-Private Partnership Petition Committee Tribunal, and how, when it was created, how it works, and how many the composition or the architect of the tribunal.
Okay, thank you very much. I hope I am able to answer I am a new chairman. I am a COVID chairman. One of our members is complaining, Madam Moderator. Oh, can you hear me?
Yes, I can hear you, Prof. We can hear.
Okay, I was going to start by saying that we are the second tribunal to serve the public-private partnership petition area. A former one existed under the previous act, but there is a new Public-Private Partnership Act 2021, which has transitioned us into the second generation committee. The committee is appointed by the secretary in charge of finance, that is the treasury, and it has a chairman who should be qualified to be a judge of the High Court, and 4 other persons with knowledge and qualifications considered appropriate by the cabinet secretaries. 2 persons are nominated by the Council of Governors, who should not be members of the county executive committees. And all of us hold office for a period of a 3-year term. What kind of cases do we handle? We are mandated to handle grievances that are brought against decisions made either by the Public-Private Partnership Directorate, the Public-Private Partnerships Committee, or any contracting authority, which includes local, the county governments. These disputes are either about a tender process or a project agreement. I'll stop there for the time being so that we can hear what members would like to further, or want me to further elucidate.
Thank you very much, Professor Muigai CS, for that. Liz, the floor is yours. Will you also tell us how the tribunal started, the component, and the architect of the tribunal? Thank you.
All right, thank you. So we are also the second tribunal to sit. Before we were known as the competent authority, up until the 2019 amendments to the Act that amended the name Competent Authority to the Copyright Tribunal. So we are constituted under Section 48 of the Copyright Act. And under the Act, it states that the tribunal shall consist of not less than 3 and not more than 5 persons. So currently we are 5 members, and I as the chair. And basically we handle matters under the same section as well. In 2019, they introduced, we listened to matters of disputes, or other disputes over registration of copyright. That was not there before 2019. And then we listened to appeals that pertain to the decisions made by the Kenya Copyright Board. So for example, if the board refuses to grant a certificate of registration to a collective management organization, commonly referred to as CMOs. And by CMOs, we're talking about Music Copyright Society of Kenya, MCSK, Free Performance Rights Society of Kenya, and Kenya Association of Music Producers, CAMP. And we sort of have sort of a newcomer known as Mpake, Music Publishers Association of Kenya, who had also been licensed before at one time when MCSK was deregistered, or rather their license was revoked. We also listened to appeals against imposition of unreasonable terms or conditions by the board for the grant of a certificate of registration. Predominantly this would be in relation to the CMOs. And then we listen to matters concerning unreasonable refusal by a collective management organization to grant a license in respect of a copyright work. And I believe we know what CMO's work is, and they basically license users of musical and audiovisual works to perform them in public places, or public performance as we call it. So they issue those licenses. And also listen to matters of imposition of unreasonable terms or conditions by the CMOs for the grant of a license in respect of a copyright work. So if one feels they are aggrieved by the CMO in regards to licensing of a copyright works, they'd come in and lodge a complaint with us. And then we also have a mandate under Section 33A, where there's a grant of licenses in copyright withheld from Kenyan market, where initially a complainant would first proceed to the Kenya Copyright Board, stating that either it's a certain author of a works or a rights holder is withholding their works in the Kenyan market and they find it unreasonable. Then the Kenya Copyright Board would pass a decision. If the author now feels aggrieved based on that decision, they can proceed to lodge a complaint or an appeal to us. And then under section 27, under section 27 of the Copyright Act, subsection 2, which talks about broadcasting of works incorporated in audiovisual works, the tribunal can grant fair compensation from a broadcasting authority in the absence of an agreement where an audiovisual work is used, or rather a musical work is incorporated in a broadcast. So where a broadcasting authority broadcasts audiovisual works in which a musical work is incorporated, the owner of the right to the broadcast in the musical work would seek fair compensation in the absence of an agreement. And then lastly, under section 37, we can grant Anton Piller awards to help preserve any evidence in relation to a copyright dispute. Thank you.
Thank you very much, Liz, for quite an elucidative way on how the tribunal works. The next question, although I didn't hear you mentioning how the architect and the composition of your tribunal.
Yes, I mentioned we are 5 members, and the Act states that a minimum of 3 and not less than 5, and with a chairperson of at least 7 years. Not less than 7 years standing in the profession. The Act doesn't mention any qualifications per se, but in the previous provisions before the amendments, it had stated that they would, sort of have competent knowledge in matters copyright.
Thank you very much for that. The next question that we also want to understand about your tribunals would, if one is aggrieved, and from what you have highlighted, this question is posed to both Professor Githu Muigai, CS, and Liz. How does one approach your tribunal? I will start with Professor.
Thank you. I think I should have mentioned that other than myself as chair, we have Mr. Sadiq Duofa, Ms. Eunice Lumalas, who is actually a member of the Law Society, and Mr. Mohammed Abe and Ms. Janice Kotut. We are expecting 2 more members to be appointed by the Council of Governors once it settles down. Now, we are supported as a committee by a petitions committee secretariat, which is in Milimani Law Courts. And members can find very useful documents relating to us by visiting www.judiciary.go.ke and then searching us. How do you approach us? How do you approach a dissatisfied party? Files a petition before the committee through the e-filing system at the judiciary portal, by the way. And this petition must be filed within 7 days of the decision of the authority that you are complaining about, either the directorate in the Treasury or the committee or the contracting authority. And my committee is obligated to hear and determine the matter within 28 days of filing. So far, since I've been chair, we've had 2 major cases. One is on the construction of the Lamu to Isiolo road, where a party complained that there was a variation in the parties that were invited to the bidding process. The other one was the operation of the Lamu container terminal, and these 2 decisions are available for perusal. Our decisions are appealable to the High Court. So far, we from the 2 that we've had, we've not been overturned yet. So we hope we are doing the right thing. I think that answers your first part of the question, and I'll stop there.
Thank you very much, Prof. The same question I'll pose to you, Liz. How does one approach your tribunal? Like a very good case when the musicians are being paid 2,500 as compensation.
So before I get there, let me also introduce my members of the tribunal. My members constitute Ms. Helen Kiende. We have Mr. Wilfred Ogot, Lucy. We have Caroline Apio Omaya and Joseph Ndongo Kihanya. Those are the members who are part of the Copyright Tribunal. I think when we're talking about the Copyright Tribunal, kindly mute there's a counsel whose mic is on and is disrupting. Thank you. So I hope we had all right, so I hope my members' names were heard, and they're also joining virtually in another room.
Sorry, we did not hear them.
Yes, whoever is manning, please make sure you're muting the rogue mics in good time. I shall repeat the members. We have Helen Kiende, we have Wilfred Ogot, popularly known as Lucy, Wilfred Lucy. We have Caroline Apio Omaya, and we have Joseph Ndongo Kihanya. Those are my members. So in the question first that has been posed by Teresia, I think one thing that's really important for the lawyers present to understand is that unfortunately for us, our mandate is very restricted in terms of the matters we can hear, which I highlighted earlier. So, but I think as members interact with us, we will see the kind of loopholes that are there. So unfortunately, right now, we don't handle those matters around royalty payments to the artists. That is not in our jurisdiction. So if you want to file a matter in our tribunal, we have some semblance, I use that word deliberately, some semblance of rules that accompany the Copyright Act that give guidance on how to file a matter in the tribunal. We are hoping to fine-tune them in the coming days. So keep an eye out as we put them to stakeholder participation so that we have better rules. But I'm sure for those who have interacted with the Copyright Act, you can see how those rules are in a terrible state. However, we'll be sitting for the first time using the e-filing system. So we are waiting to be mapped out for a virtual sitting. But even then, the following are the things that you keep an eye out in terms of applications. So we have under the rules, the CR 17, which is an application for compensation of royalties to the authority under Section 27, which I mentioned earlier, and that the filing fees would be 5,000. We have Rule 18, an application, the rules real competent authority, but it's Copyright Tribunal, an application under Section 48(2) and 21(1) that I mentioned earlier, and the fees is 10,000. And then replies are done by CR 19, replies under Section 48 and Section 21 as mentioned, and the filing fees is 2,000. And then we have the CR 24 when there is a request for an extension of time, and you pay about 500. If there's anything that is not provided for that we are mandated to listen, if you're going to file, you will you'll pay a filing fee of 1,500, and most probably the application form is what you would likely use, which is CR 18. But in the coming days, we will be fine-tuning those rules so that then they are better, they're easier to understand and associate with. Thank you.
Thank you very much, Liz. You have mentioned how much one needs to file. Prof, how much does one need so that they can file a matter before your committee?
Madam Moderator, you have asked me a very technical question, but let me try my best. I think what you do is that you file an affidavit of service. It's about, Yeah, let me go through the fees. The filing of the affidavit of service is about 150 shillings. Filing annexures is 20 shillings. List of authorities is 50. List of documents is 75. Memorandum of appearance is 50. Mention notice is 70. Notice of appointment of advocates, 150. Submissions, 75. Taking particulars of plaintiff, 100. What am I saying? It's a very affordable tribunal. It is intended to encourage free flow and free access. The petition, as I have mentioned, must be filed within 7 days of the decision in dispute so that we can render a dispute with a reasoned opinion within 28 days. Unfortunately, there is, the tribunal does not anticipate that there must always be an advocate. So our procedures are fairly informal. We try not to be very, very technical and try to accommodate even if we were approached by a lay person. What should be included in a petition? Under our petition committee guidelines, which were enacted earlier in 2014, that we require the name and address of the parties, the tender name and reference in dispute, the decision in issue, the date of the decision, copies of relevant documents, the grounds of petition, etc., something like that. It's quite informal and quite inexpensive. So I think that I have answered your question. I hope I have answered your question.
Thank you, Prof. And yes, you have answered my question. Liz, on the same issue, how much relatively, you had mentioned something with 5,000. Is it that is the amount fixed, or it can go lower or higher?
So it will depend with the number of filings and replies that one would want to engage in. But as you can see from the amounts I was mentioning, if the matter is relatively uncomplicated, a maximum of 20,000, 25,000 is what would be in filing fees, thereabouts. But what comes to us, maybe 40,000 thereabouts. Again, even for us, I believe everyone knows that the nature of tribunals is it's relatively informal compared to the courts. It's supposed to be access to expedient justice. We're supposed to be easy to associate with. Whoever is associating with us needs to feel like they're connecting. So we don't have formalities as well. I think in the question, what I also did not mention is that under the Act, in terms of how to lodge appeals, we only have provisions for how to lodge the appeals on the decisions made by the Kenya Copyright Board. And basically, the Act states that a person aggrieved by the decision of the board within 60 days from the date of the decision shall appeal to the Copyright Tribunal. And then the board shall provide written comments on any matter over which an appeal has been submitted to the Copyright Tribunal under this section upon request from the tribunal. And then the Copyright Tribunal shall issue a decision on the appeal within 30 days from the date of appeal. So those are our general timelines. Yeah.
Thank you very much, Liz. And on those timelines, but in any extraneous circumstances, can it be extended, or are you stickler at following those timelines?
I think it would depend on the situation. It would depend even on the parties that are appearing before us, because we are also playing a role in terms of guiding either the applicants or the claimants. We refer to them as applicants in our tribunal. So it will depend, but of course, for purposes of expedient of justice, we cannot, of course, overstretch it. Ideally, in a tribunal, the goal is to grant, justice as fastest as possible. Yeah.
Thank you very much, Liz. Professor Gidu, yes, you had mentioned that the timelines that you have is 28 days for you to hear and determine a matter, like the two example matters that you've given. Barring any extraneous circumstances, what if there are extraneous circumstances? Can you extend your timelines?
Well, the time by which a complaint should be made, the 7 days, is quite strict. The time by which we should render an opinion is quite strict. In between, we have discretion. If we have directed that something should be placed with the Secretariat by a certain time, and there is a little problem with that by a day or two or so, we have a little discretion inside there. And we try to be as accommodating as possible. As my colleague has said, Ms. Lenjo has said about her own committee, the spirit is to have due process, to have administrative justice, but to be flexible and accommodating. In the two cases that we've had, luckily we've had counsel on both sides, both times, and that has been exceedingly useful because, as you can imagine, this is an emerging area, and there are so many ways in which some of the language of the statute can be interpreted. So it's been a good experience so far. Thanks.
Thank you, Professor Gidu, on that. Allow me to ask a follow-up question. You have mentioned in the previous matters that you have handled those two matters. There was representation by counsel. As per your tribunal, does one need to be represented by counsel, or they can do self-representation?
Well, in the nature of the projects that are in this area, indeed, for example, up till last year, the process had not opened up to county governments. Now it's been opened up to county governments. The pipeline of deals, and I use that word in its technical sense, not in its other sense, the pipeline of deals, both at the Treasury Directorate and within county government, is going to be very, very good. And therefore, I think that this is a new area where advocates who dedicate themselves to this transaction will find themselves fairly busy. Because the deals are very huge, in the sense that the reason that the government is going out to the public sector to invite participation is because the deals are so huge that to finance them from public coffers is not economical. So most of the parties, I think, would prefer to be represented by counsel to ensure that their cases are fully argued. I have seen matters that were done by the previous committee that we succeeded. And even in those, I think almost in the majority, the counsel were involved. Thanks.
Thank you very much, Prof. And Liz, the same question. Does one need an advocate to be represented before your tribunal, or they can do self-representation?
And our act, one does not need to be represented by a legal representative or any representative. They can appear as themselves as well. So it's flexible and it's accessible to even Wanjiko, also known as the common mwananchi.
Thank you very much for that. I want to ask both Professor Gidu Muigai, CS, and Ms. Lenjo, why file before your tribunals and not before the court?
Well, in our case, because it is the statutory mandate, that is what is required to do. You can appreciate that what Parliament intended to achieve was to make this, was to make the PPP process expeditious. So they wanted that even where a dispute arises, there is a committee, and that committee is time-bound, hears the matter in a non-technical way, renders a non-technical decision. There is a very narrow window to the High Court, and then the project takes off. So the monopoly we have is a statutory monopoly. Thanks.
Thank you very much, Prof. Madam Liz?
So why would one appear before our court, our tribunal? One, it's because of the nature of specialization on copyright matters. Sometimes people tend to trivialize matters copyright, yet they can be very technical, and there are certain issues that one needs to delve into. Time efficiency, of course, and expediency is something that can be achieved. That is why, as you can see through our timelines, and as we establish our regulations as well, we will be very deliberate in matters of time and how fast we can arrive at a decision or a judgment or ruling, whichever the case may be. And then, of course, over time, all the users of the tribunal will see what other opportunities are there. As I said earlier, unfortunately, our mandate is very restricted at the moment. So if you look at Section 27, we can only give fair compensation when we're talking about use of musical works in a broadcast or audiovisual work. So you can see, and yet there's other forms of unauthorized use in that regard. Also, when we're talking about disputes over copyright registration, at least we are able to confirm and assert who would own the copyright in the instance copyright registration is being disputed. So, of course, the specialization definitely, and over time, we will see that efficiency will be achieved. And the tribunal is much needed when it comes to copyright industries, because as we always say, the intellectual property has a shelf life of a banana. So our tribunal is essentially a very important player in the creative industries system and structure. Thank you.
Thank you very much for that. And I want to ask, are there any opportunities that are there for advocates in your tribunal, Liz? Because clearly your tribunal is strictly to do with anything creative.
So I'd say there's opportunity. We have a huge gap when it comes to lawyers who understand matters copyright and matters intellectual property as a whole. So I think the more young lawyers and older lawyers in the profession, those who are interested should pursue, consider pursuing copyright matters. There's a lot of opportunity. I would give an example of myself. I exclusively practice intellectual property, entertainment, media, fashion law. Those are the clients I represent, and on matters intellectual property. So there's opportunity. I think one thing that I would like to inform and caution fellow advocates is that, one, unfortunately, our profession is not in good standing with creative entrepreneurs. We are, unfortunately, a few people have been spoiling for us. In Swahili, they say, Nazimbovu harabuya nzima. Yeah, one coconut will spoil for the rest of us. And I speak specifically to at least 2 weeks ago, for those of us who are very active on social media. 2 weeks ago, there's an author. He's an author in the film industry. He approached a lawyer to give an opinion on a script that allegedly was his. He shared with a friend, and he thought that he had access to a lawyer, only for a few days later for him to get correspondence from the same lawyer he thought he had on his team. So that just tells us that in terms of honesty, we really have a lot to do in terms of cleaning up our reputation, but opportunities are definitely there.
And what kind of opportunities are there? Do you do MOUs with the LSK? Do you do MOUs with pro bono advocates to represent people who are coming before your tribunal, or?
All right. So as you know, we are newly constituted in terms of the second sitting. So those are things that we can explore, and we are open to dialogue and conversations. We are definitely not blind to the fact that there are many, copyright holders who need access to legal counsel. So, in partnership with LSK Nairobi and LSK in general, that is something that we're definitely open to. And we hope in the coming days, that could be one of the projects that we're going to pick up to provide opportunities to young lawyers and lawyers at large, as well as granting that easy access to justice for the creative economy practitioners and artists. Thanks.
Prof, thank you very much, Liz. Prof, I'll pose the same question. What kind of opportunities lie before your committee or tribunal for lawyers?
As I mentioned earlier, because this public-private partnerships involve a lot of money, from the inception of the projects, most of the people involved would have hired a law firm to guide them through the contracting process and the bidding process and so on. So there are two aspects, there are two parties, there are two phases. There is the pre-dispute phase, which is very, very, very fertile ground for good, energetic transaction lawyers. And then, of course, there is the dispute resolution phase, which is my committee and the High Court after my committee has made a decision. And again, there is a very good, very much like in the public procurement space, that is going to open up a lot of opportunities for lawyers. Thank you. Have I lost
Thank you very much,
Madam
Prof. So, no, you have not. Thank you very much, Prof. So in the spirit of all those opportunities that lie therein for lawyers, your committee tried reaching out to LSK, the Nairobi branch, National Council, to find a way where they can have a good MOU to engage more lawyers on board, or even do you invite lawyers to even provide services for people, even if it's through a pro bono scheme, and then through the funding of the judiciary, you can give them something?
In my case, I think that what we ought to be doing, and I think we will be doing that very shortly, is to have a sensitization process where we share with lawyers what it is we are doing and the opportunities that exist for them, and have them help us in the process of developing our regulations and the framework for dispute resolution. But we are less constrained than other tribunals because the very nature of our work means that the client is already inclined to retain a lawyer long before the dispute has arisen. So from that angle, I think the only sensitization that is required actually is in the counties, because I would like to hope that when disputes arise involving county governments and private partners, and that they will not come to Nairobi to look for lawyers. They will look for lawyers from where the contracting had been done. So it is the LSK branches within the counties that we should be sensitizing about these opportunities. And we are happy to work with you in that regard.
Thank you very much, Prof, for that opportunity. And in the same spirit of sensitization and public participation is guided by Article 10 and 118. It is my humble request that we can engage lawyers to do trainings on those counties about the committee. Thank you.
Absolutely.
We have some questions from the members, and I'm going to start with the one which has been posed by Polycarp Muriaise to Liz. The question is for the copyright board, which Liz Lenjo heads, does the board quite guide creatives on matters to do with drafting of the contracts, evaluating the contracts entered by the creatives, among other legal matters touching on copyrights, for those who do not have legal representation? Or they just let them put it for themselves the way they prefer?
All right, so let's start with clarification. Under the Copyright Act, we have the Kenya Copyright Board that is established, and we have the Copyright Tribunal, the dispute resolution body that is established. So Kenya Copyright Board has a different mandate, of course, from us. And Kenya Copyright Board assists in matters copyright. They're the advisor to the government. They put in structures to ensure that copyrights are well understood and regulated in the country. So the Kenya Copyright Board itself has really been at the forefront of sensitization of the creatives and the copyright holders or potential copyright holders on matters copyright. So every year, at least under my observation, I have seen at least maybe up to 6 or 7 workshops that they normally have to empower creatives and artists. And in the 12 years or so that I have been a specialist in matters IP, we unfortunately don't see a lot of lawyers attending these sessions. So one of the things I would call upon my fellow advocates is that let's attend these trainings so that you also understand what's happening on the ground. Copyright related industries also have certain nuances in terms of how I apply copyright law in the publishing industry. And publishing, I mean book publishing industry is, would have certain nuances different from the music industry, for example. If we're talking about audiovisual works, there are certain nuances you need to be aware of. If we're talking about software as well, there are certain nuances you need to be aware of. And you can only know and interact with some of these nuances also when you're on the ground. So Kekobo has been doing a good job at that. And hopefully, as we map out our stakeholders as well, we'll definitely be having some collaborations. For us right now as the Copyright Tribunal, we listen to disputes. Should a matter need guidance in terms of an applicant needing guidance, I mean, if it's part of what is under contention or they need guidance on as we're giving a judgment, I mean, we would definitely do that because there's a need to give better precedence in terms of some of these legal documents that are being churned out as far as copyright matters are concerned. Thank you.
Thank you very much, Liz, for that. We have a question to Professor Githus, yes. Someone is, the same person, Polycarp Muriasi, is asking, how was the efficacy of the public private partnership petition has it been tested, the efficacy of the public-private partnership petitions? Has it been tested?
I think we have, as I mentioned earlier, during my tenure, which is a COVID, it was the COVID time, we did two major cases and therefore rendered two major decisions. So far, we have not been overturned by the High Court. I assume that means that the parties found the two decisions to be sound and complied with them. I expect that the traffic to our committee will increase substantially because, as I said earlier, there is a huge pipeline of deals that the Treasury is handling and that is going to come through from the county governments as they entrench PPPs within county planning of infrastructure. So I think so far there is no cause to believe that the committee is not equal to the task. Thank you.
Thank you, Prof. Yes, and you also mentioned up to date, there have been no appeal to those decisions you rendered.
All right.
Yeah, thank you. Another question to you, Prof, is how do you balance the need for transparency and accountability vis-a-vis the protection of commercially sensitive information about the tendering process? Bearing in mind, it's quite a fundamental issue in PPCs about confidentiality of information exchange between the bidders and the contracting authority.
Well, that's a very good question. So far, we have not had to confront it because, as I said earlier, the parties that have appeared before us have done so through counsel, and counsel has been able to protect the various interests of the parties that they represent. Don't forget also that we come after the tendering, the bidding and tendering process is already complete. So this material that is brought before the committee is already available to both parties and others who participated in the bidding process. So this has not arisen as an acute problem so far. However, we are not an open tribunal in the sense that people can walk in and walk out. You know, it's like a parties only tribunal in the sense that if you go to court one in Milimani court, you can listen the whole day to all the cases there. In our case, I doubt that people can walk in to listen generally to the proceedings. We've not had to confront that. In fact, rarely have the real bidders appeared. They have actually sent their legal representatives and their technical advisors. Thank you.
Thank you very much, Professor Gidu, CS, for that. We have a question for both our panelists, that is Ms. Liz Lenjo and Professor Gidu Muigai from Felson Odongo. Is asking, what is the procedure where members of the tribunal have divided opinions over a matter? How do you handle that? Let's start with Ms. Liz.
So, well, since we are yet to sit and, in the previous sitting, we never encountered such. At the end of the day, it's the principles of copyright law that will prevail. So if there is a sort of a divided opinion, at the end of the day, the question will be, what does the law provide in this situation? And, as lawyers, we know that there are situations where when you're ruling or when you're giving a decision over a matter, there may be rulings also that may be involved, some certain pronouncements that you may have to make, again, based on the law, right? So that at the end of the day, you also clarify the position of the law. So the law, at the end of the day, the position of the law is what will prevail.
So you're trying to tell us at such juncture, you have to insist the law is very clear.
Yes, indeed. And I think sometimes as lawyers, we complicate things. Like for me as a practitioner, as a copyright practitioner, having even analyzed jurisprudence from advanced, jurisdictions, at the end of the day, you will see after you have combed through all the nitty-gritty, you will find that the issues can be clearly elucidated and ruled upon.
Thank you. And in the same spirit, there's a question, a follow-up question by Felson. At the courts, if a judge has interest in a matter, they recast themselves. So what is the procedure where a member of that tribunal has an interest in the matter at hand? And does the chair have a casting vote?
So I'll start with whether the chair has a casting vote. Yes, the chair has a casting vote. And then also the other members respectively also have a casting vote. But at the end of the day as well, substance is what really matters and carries the day. When it comes to conflict of interest, a tribunal member must declare a conflict of interest where a matter is appearing before them and they recuse themselves so that then they cannot adjudicate over a matter where they have pecuniary interest, or they may have even assisted in the legal procedures of that matter that is appearing before us. That is something that they must put it forward to the tribunal. Thanks.
Thank you. And what if in the circumstances that members declare that they have conflict of interest and you remain without a quorum, what happens next?
I think the chances of that happening are highly unlikely. But
in
when
the circumstances that it happens?
In the circumstances it happens, then unfortunately we would not be rightfully constituted. So I don't know. Perhaps we would refer them to the High Court. But the chances of that happening are, in my view, tend to be very slim.
Thank you very much, Liz. Professor Gideon Mugaisi, yes, I will pose the same question. What are the procedures where members of the tribunal have divided opinion over a matter, especially like those two matters that you handled? And what is the procedure where a member has an interest? Should they recast themselves like how the judges or magistrates do? And does the chair have a casting vote?
Well, let me start with the last question. The chair has no casting vote. So all votes are equal. The decision making is the quorum is by half of the members. The decision is by consensus or by a majority of half of the members. Now, my own view is that it is the duty of the chair always to try to achieve a consensus decision. And in the two cases we've done, what we have tried to achieve is to agree on the issue in dispute between the parties and then between the members. So when I summarize the case for my members at the end of each hearing, my duty is to ask the question, to this...
Prof, just a minute. Maureen, please mute your microphone. And the LSK Nairobi branch, please mute all the microphones of everyone apart from the panelist. Thank you.
I think
Apologies,
that no problem. The chairman's duty is to try and achieve a decision by consensus, and therefore to make sure that the parties, the members agree on what the issue presented is and what the law applicable to that issue is. In the two cases that we have concluded, that has been quite straightforward. So what then happens is along the same way that the Supreme Court would work, well, at least of the, which is for the chair to ask for a draft to be prepared along the lines that the consensus has emerged. And then that draft would be circulated among the members, and then it would be refined. And if the members feel that the language is now sufficiently moderated and that the legal issue is sufficiently articulated, then we deliver the ruling in that regard. If there was a dissenting voice, then we would have to go with the majority. If the chair was dissenting, then the majority would write without the chair. I hope that kind of day will never come, because I believe strongly that it is the chair's duty to try and harmonize opinions and create consensus. Thank you.
Thank you very much, Prof. And if a member has interest or conflict of interest, should they recast themselves?
Yes, I think that as a matter of justice, fairness, and the integrity of the process, I would answer that in the affirmative.
Can I ask a question?
Sorry, who is speaking?
My name is Stephen Oundo. I wanted to ask Prof a question just on two things he's just articulated. One is on, I think the principle of consensus is good, but it shouldn't be that it is driven. It should be like an output. Otherwise, the rest of the members may feel if they are not with the chair, then they are in conflict. That's just my view. And then the one
I think that's a good point. Oh, sorry, Steve, yes. Go on.
Yes. And then the second one is to do with what you just said about conflict of interest. Should it be that one of the members declares their position and then the rest of you decide whether you think he's conflicted or not? Because I may think I am conflicted and I state my position, and then maybe from where you sit, you don't think it is. I don't know how you would articulate that. Thank you very much, Prof.
Let me start with your first point, and I agree entirely with you that the consensus should not be rammed down the throat of any of the members present. It should emerge from the conversation, from the discussion around what are the issues of fact and what is the law applicable. For example, let's say it's a jurisdictional issue. And the first challenge, because we do have preliminary objection, the first challenge is a jurisdictional one. Again, there we isolate the issue very quickly, say, is this a sort of matter that the drafters of the statute anticipated would come before us? And if we go around the table and the consensus emerging is, it is too early to tell because we haven't delved into the evidence, let's assume jurisdiction and hear the evidence and so on. Then we move in that direction. But I agree with you entirely. It shouldn't be forced. Now, on the issue of conflict, I think that the member ought to tender before the committee any information which, if it arose after the decision, may be considered by a third party looking at the process to have been a conflicted position. Then allow his colleagues, her colleagues, as the case may be, to then determine whether in the collective opinion that there is a conflict or there isn't a conflict, or whether there is a perceived conflict or a real conflict. Thank you.
Thank you very much, Steve, for those questions, and thank you very much, Prof, for elucidating on the same. Members, any other person who has a question before we come to the end of the session? Well, it seems like all our members have been satisfied with the session, and all the curious questions that they had, they've been answered by our two great panelists whom we have been privileged to have today in our session. As we are going to wind up, we are going to ask for the location or address where members or people of the public can file or approach the tribunal with. We'll start with Ms. Lenjo.
All right.
And also,
Sorry,
as you're doing that, you can also post it on the chat. Thank you.
All right, I'll do so. So one thing I had forgotten to mention is that us as the Copyright Tribunal, we are under the judiciary, under the Registrar of Tribunals. So we sit at Forodha House, 4th floor. That's in Upper Hill Close, the building just next to Milimani Courts. I will share the phone number in the chat, and we have an email that will be soon activated, copyright@court.go.ke. I will share the same on the chat. At this point, do we give our parting shots or do we just answer that first?
Yeah, just that. Thank you.
Okay, thank
Professor Gibu, your location
Well,
and address on how?
We are a very high-tech committee because we receive all our filings through the e-portal, and we encourage hearings online. However, we have an office in Crescent House, which I think is Muqtadada Street. The chairman is embarrassed to say that it's not sat in that building because it's not been necessary. The Mwindi Bing, Muqtadada Street, Nairobi, that is the Crescent House. We are trying to have an on face-to-face modified courtroom at Milimani, which will be available. But so far we have not needed it. Members are free to look through the judiciary website and they will be able to find particulars about us, as I had stated earlier. Now that a parting shot has been mooted, may I have a parting shot?
Not yet, Prof. Before we go to the parting shot, it seems like there's a member who has a hand up, and Asuga, the floor is yours.
Good afternoon, and thank you very much, Prof. and Senior Counsel and Chairperson Elizabeth, for those insightful deliberations and elucidation on the mandates of the tribunal. I am the Registrar of Tribunals based at Forever House, and I just wanted to make a quick clarification on the issue of fees for copyright tribunal. Before, as the Honorable Chair had mentioned, there used to be payment that used to be made, but after gazettement of fees by the Honorable the Chief Justice, the fees now is a flat rate of 1,500 for the filing. So any document being filed on the e-file, or even, we don't do physical filing for tribunals, we do e-files mostly. It's 1,500, and if a party is not able to do e-filing, they are able to send us the document either on email, then we convert them to an e-file, or they approach the nearest court station, and they'll be assisted to actually do the e-filing from the court station, or come to our offices with the hard copy and we would convert it into an e-file at the office if the party is unable to do e-filing. I want to thank the chairs for agreeing to come and speak to our stakeholders. Thank you very much.
Thank you very much, Anne, for that further information. Well, members, you have heard from our panelists, and at this juncture, allow me to say it was we have had a very good session, and I want to give the opportunities to our panelists to give their parting shots. Ms. Lenjo.
I think for me, my parting shot would be that one, I think it's really important as advocates, we know the respective tribunals and avoid forum shopping and save the justice system time and money. I would also like to encourage that more advocates learn about copyright matters and engage in courses that enrich that knowledge or that area of expertise. So like I mentioned earlier, there's Harvard X by Copyright. Copyright X by Harvard. And they usually have campuses in different parts of the world. So the Kenya one is housed by the Go Down Arts Center, and it's open to lawyers and non-lawyers. So we always welcome them to be part of the knowledge sharing platform. And for the lawyers as well, the World Intellectual Property Organization Academy offers courses on the WIPO Academy platform, and they're all digital/virtual courses. They're very affordable. The Intellectual Property 101 course is usually free, so please feel free to engage in such courses and build your knowledge. I would say that I'd like to say finally that please expect more engagement from the Copyright Tribunal. We will be, reaching out when we are. We will be reaching out when we are sharing the draft regulations or rules. We'll be sharing our strategy and communications in terms of what we are up to, stakeholder engagement, and any other collaboration. And we are happy to receive any feedback, any suggestions that you may have as well, either through LSK Nairobi or through the email that we've shared that will be soon activated. And also feel free to even reach out with your suggestions, either on social media, now that it's become a popular channel of communication, and we can see how to better ensure that all stakeholders are part of dispute resolution in copyright industries. Thank you so much, LSK Nairobi, for the opportunity. Yes.
Thank you very much, Chair Liz Lenjo, for that. Prof. Mugaisi, the floor is yours.
I just want to thank LSK for organizing this event. and to thank my registrar, Anna Suga, for her support in preparing me for the Q&A. I hope I have not let her down. And finally, I want to encourage our members, especially the younger members, to become involved in the new law that is unfolding around such areas as we have discussed this afternoon. There is so much work out there that we should keep an open mind. Thank you so much.
Thank you very much, Chair Liz Lenjo and Professor Githuwigai SC for this good session. Members, you have heard from our panelists who are not just any ordinary panelists, but these are panelists with robust experience in the respective positions that they sit in these tribunals and committees. These are people who are ready and willing to serve all of us so that we be able to execute and ensure justice for all. Ensure we go out there, we read more about these tribunals, and above all, we get to understand the opportunities that lay therein as we have been elucidated. At this juncture, I want to call to declare that this session is officially over, and encourage members to keep on attending more and more on these Know Your Tribunal sessions, because they will equip us with so much knowledge, and above all, we'll be able to understand and fathom what goes around our tribunals. So that is just like our chair Liz has mentioned, we don't need to waste time on filing matters which are not supposed to be filed in respective courts, but we identify the respective tribunals and the place that we need to file the matters. Thank you, and may we all have a lovely afternoon.
Thank you.